You sought and obtained a temporary order of protection in this case, and this hearing today is to determine whether or not there is cause to extend that order of protection for up to 1 year. It is your petition and your request to obtain an order, so I must first ask you, do you still desire to have an order of protection?
Yes, Your Honor.
Mr. Lutz, this is, again, as you heard me say, a hearing today to determine whether or not an order of protection should be extended, and for that reason, you have the right to simply either agree to the extension of the order of protection or to waive the order of protection, or to contest the extension of the order of protection. Do you wish to contest the extension of the order of protection?
Yes, Your Honor.
All right, have a seat at the table. Ms. Lutz, if you will come around to the witness stand, I'm going to ask you to have a seat. First of all, you've been placed under oath, so I will remind you, you are under oath. This is your hearing today for you to tell me why you feel that there's a need for an order of protection. And even though there's one been issued, I did not issue that order of protection, I don't think. So you need to start from the beginning and tell me every reason why you feel that there needs to be an order of protection, and you need to speak directly into the microphone.
Yes, Your Honor. We were divorced in 2024, May of 2024. We do share a daughter together. Since being divorced, it has been countless times that he has been disrespectful, harassed, left voicemails that were threatening, and I just don't feel safe. He is currently living on the other side of New Johnsonville from where I am, and he has no business on my road. There's no businesses there. There's no reason for him to be there. It's not a way for him to get to work, and he has been on video driving past our home. With his history of domestic violence against me in 2021, I don't feel safe. He's made threats against myself and my fiance. So I'm not sure what I'm supposed to do. I was told by Officer Bailey in New Johnsonville that this is probably my best bet to get like the harassment and such to stop.
All right, guys. The courtroom opens with a temporary protection order already in place and now hanging by a thread. The judge makes it clear this hearing is about whether it continues or collapses entirely into nothing. A direct question is asked, do you still want protection? And the answer locks the tone of the entire case.
Your affidavit of your petition for an order of protection, you state that he has made threatening statements towards you that cause you to fear for your safety, and that he has been arrested in the past for domestic violence. Was the arrest for domestic violence against you?
Yes.
And when did that occur?
In 21.
All right, and what happened to that case?
So we resided in Waverly, and we were at our home, and he followed me and the children outside with a loaded shotgun.
Okay.
And we ran to the neighbor's house and took shelter.
When he had the loaded shotgun, did he threaten you with the gun?
Yes.
Okay. What did he say at that point?
Well, I can't recall exactly what his exact words were, but he did come out of the house, and the shotgun was fully loaded, and he racked it on the deck.
He racked it?
Yes.
Okay. Then you said that he had left you a threatening voicemail. What, on April the 19th? What did he say in the voicemail?
Well, the voicemail was not left on April 19th.
Okay.
That was when our last altercation was, when we were exchanging our daughter. But the voicemail stated that I needed to answer the phone and he was going to come get my hands.
Okay. And you took that as a threat against you?
Yes, sir.
And then you said he threatened you and your boyfriend on April the 19th during the exchange of your daughter?
Yes, sir.
Tell me about that.
The courtroom quickly shifts into heavy testimony about fear, threats, and a violent history that cannot be ignored. A past incident involving a loaded shotgun in 2021 is brought up, painting a disturbing picture of escalation. Allegations of threatening voicemails add more pressure, turning words into something perceived as danger.
So we meet in New Johnsonville at the Dollar General because I don't feel safe or comfortable with him coming to our home. So we met there, and just as he was pulling in, my fiance and I were sitting in separate vehicles because my fiance was coming through town and saw me waiting to pick Millie up. So he pulled into the parking lot as well. And as soon as Christopher pulled into the parking lot, he jumped out of his truck and started shouting at myself and my fiance, which caused our daughter to scream and cry. And I mean, I have a video of it. But he threatened my boyfriend, and he, flicked his cigarette at my feet and said he was going to get me. So those are the kind of things that I can't tolerate anymore.
How often, you two are operating under a parenting plan that was granted in your divorce?
Yes, sir.
How often does he see the child or children that you have one child together?
We have one child together.
So how often does he have visitation with that child?
He's supposed to have every other weekend with her, and then even in odd years of holidays, it's just like a basic.
Okay. And has he been exercising that visitation?
I have been, since April 19th, I have kept Millie from him because I don't feel safe with the exchange. I don't feel safe with her being there. He's an alcoholic. And there's been times where he hasn't had food to feed her and stuff. So I didn't feel safe with her being there.
Well, you understand this order of protection is designed to protect you from domestic violence.
Yes.
It is not intended to supersede or set aside a parenting plan that's issued in your divorce case, and you will have to go into that divorce case to alter or amend any sort of parenting time that he might have.
Yes, Your Honor.
So if in fact
the conflict spills out of private space and into public settings like custody exchanges in parking lots. A Dollar General meeting turns into shouting, accusations, and emotional chaos witnessed even by the child. Each side claims fear and aggression, showing a relationship completely fractured beyond repair.
were to have continued to let him have the visitation with your daughter, is there some other arrangement that can be made for the exchange of the child?
Absolutely.
What would that be?
I would either ask my mother to meet him. That's really my only other option. I'm a transplant here from Chicago. I don't have any other family except
But your mother lives here?
She lives here in Waverly, yes, sir.
How does she and your ex-husband get along?
I would say it's, fine. I wouldn't say there's any animosity there.
All right. Anything else you want to tell me about the situation? You and your allegations say that he's driven past your home and that he has verbally told you he wishes death on you.
Yes.
Okay. Can you tell me when that was?
I can't remember the exact date of when that was, but like I said, it's over the course of the last 2 years, and this is where we're at because of it. It's just compiled and compiled and compiled, and I just.
All right. Mr. Lutz, you're representing yourself, and as a result of that, you have the right to ask questions. This is not a point for you to argue with her, but rather for you to ask them in a question form. If you want to do that, you need to come to the podium, and we'll let you ask whatever questions you want.
In 2021, what was the verdict on all charges that were placed against me?
It was an 11/29, so as long as you didn't get in trouble, then I believe.
The final sentence was all charges were dropped, correct?
It doesn't excuse the fact that it happened.
So was it continued for 11 months, 29 days? If there were no further problems, it would be dismissed. That's typically
Yes,
what would
sir.
happen. All right.
There's also a written statement on file of what she has said, and that does.
The judge digs into custody arrangements, exposing how the written parenting plan no longer matches reality. Visitation exchanges are now blocked, justified by fear, alcohol claims, and safety concerns. The court reminds both sides that custody rights still exist even under a protection order.
Does not correlate with what she's saying today. April 19th of this year, your fiance used your phone to slander me. It was 2 days prior when I was picking up our daughter. And then
Now you need to be asking questions. You're making statements, so you can only ask questions. I'm going to give you a chance. I'm going to give you a chance to testify, but right now you get to ask a question in a question form.
did your fiance use your phone to text me the Friday before April 19th?
Yes.
Did he block me with your phone again?
Yes, because of what you were saying.
Have you read the parenting plan?
Yes,
When it comes to, do you have a physical copy of it?
I have a digital copy, yes.
Okay. Do you understand that we have to keep open lines of communication open,
Email is an open line of communication.
then I'm not, that's for a later court date.
Anything else you want to ask in form of a question?
By verbal death threat, do you mean when I said I'm not going to have to deal with you much longer because of your family health history?
No.
I've got no further questions for her.
Cross-examination begins and both parties start challenging each other's version of events under pressure. Old messages, past rulings, and disputed incidents are used like weapons to break credibility. The judge repeatedly steps in, forcing control as the courtroom edges toward emotional chaos.
All right, thank you. You can step down.
Thank
you. Do you have any other witnesses you wish to call?
No, sir.
All right. Ms. Lotz has rested her case. Mr. Lotz, do you wish to ask any questions? Do you want to testify?
Yes, sir.
All right, come on up. You have previously been sworn, so have a seat, and I'll be glad to hear whatever you have to say.
Your Honor, I feel like this is nothing more than a manipulation tactic and parental alienation. The only time in our 12 years together and now almost 3 years divorced has been any physical domestic abuse. Teresa Louts was the aggressor. You can go back and look at the sworn statement that was made by her that about the problem that we had in 2021. And the 15th and the 22nd, I had Officer Simpson on the 15th, and then I can't remember the other officer's name, come to my house and talk to her. She said that we weren't dealing with the parenting plan just by the book, by the letter, and that we would go back and forth. And that was the weekend after Mother's Day, the 15th. The 22nd, the officers went to the wrong house. They went and knocked on the door. And so the only reason I drove past the house was to get the address to call the officer back. Because I haven't had her address since she moved there. And I just feel like I'm getting parental alienation.
When you say parental alienation, is that because of the fact that you've not been allowed to see your daughter?
Yes, and it's not the first time. This past few weekends is not the first time.
She says that she makes the allegation that you're an alcoholic and that she's fearful for your daughter's safety. How old is your child?
8.
All right. And do you drink alcohol?
I do, but I actually recently quit, but I've not drank in front of my daughter it was 2023. It was it was during the very beginning of the divorce, and I was at a friend's house. But no, my daughter has not seen me inebriated since I left the house before the separation in September of 23.
So what is the problem between you and her right now? How would you characterize what's going on between you and her? She says you threatened her. Is that true?
To my recollection, no, I've not ever said anything physically threatening or directly threatening. I may have said things that were nasty about me just waiting for her to follow her family health history due to family or lifestyle. And
what do you mean by that?
Everyone in her family passes away before 65 or 70. Then I wouldn't have to deal with her much any longer.
All right. Anything else that you want to tell me about this situation?
No, Your Honor, I just want to see my kid. I don't care if I never set eyes on her again.
Okay.
I don't want to be in the same room with her.
Ms. Lotz, do you have questions you want to ask him? This is your opportunity to ask questions. All right, then thank you. Step down. Based on the testimony, the court finds that there is cause for the extension of the order of protection, but only for a limited period of time, and that as I pointed out, this order of protection is not going to suspend or supersede the right he has to see his daughter under the parenting plan. That remains in full force and effect. And therefore, the only modification I will make is that the exchange of the child will continue to take place.
The father takes the stand and strongly rejects the allegation, calling it parental alienation and distortion. He denies making direct threats, reframing his statements as misunderstood frustration rather than intent. But under questioning, inconsistencies surface, and emotion begins to leak into his explanation.
Where you've been exchanging it, but that the maternal grandmother will provide transportation for Mr. Lotz to meet his the grandmother of the child to get the child, so that you don't have to have interaction. And by extending the order of protection for a period of 90 days, that's 3 months, that gives you all a cooling off period so that there's none of the situation. If you're going to file something in a domestic relations court to try to modify the parenting plan or to do anything else, then you need to do so. The only modification I would make at this point is that, even though I take what you say at face value, that neither party will consume alcohol while this child is present. That means you as well as Mr. Lotz. And that just means you can drink all you want to when the child's not there, but don't drink when the child is there. You understand? Both of you? All right. Then I'll fill out that order and you can have a seat outside and we'll pick it up, okay?
Is there any way in the order you can put that I can, because we don't have an actual set date in our parenting plan for the every other weekend. In the order, can you put that next weekend is my weekend so that I have a basis on if I have problems?
Makes sense to me to go ahead and start. He hasn't seen the child for a while. We'll start it this weekend, this Friday, which will be the June the 6th, 5th, June 5th. June 5th, 6 o'clock. It's Sunday at 6 o'clock.
What happens if he doesn't bring her back on time?
He'll be in contempt of court and he'll be guilty of the criminal offense of a parental interference. So you understand? You take the child according to this order, and if you don't bring it back, then they're going to be right back in here to me and I'll issue a warrant for your arrest. I don't want to do that. I want you to both calm down and remember that your daughter is 8 years old. What's going on between the two of you right now, the anger that's going on is making an imprint on her. You're basically giving her the memory of how my mom and dad are acting when I'm 8 years old. Now you think back, I can remember when I was 8 years old and what was going on. And those memories are not going to be pleasant for her unless the two of you can just say, you know, I'm done. But if she has a boyfriend that doesn't like you, so be it. You know, you don't have to put up with it. You don't have to listen to anything he says. And if he's smart, he needs to keep out of the situation. I'm just telling you, you just listen right now.
Yes, sir.
And he needs to stay out of the situation that the two of you have. But frankly, I see no reason that the two of you can't raise this child together and just get past whatever the animosity is. Threats of any kind, even just making statements about her family history that she interprets as a threat, are not doing your daughter any good. So put your daughter's best interest first and be nice to her mother, and you be nice to him.
Yes, sir.
And if the two of you can do that, your daughter has a chance to grow up as well adjusted as possible. Otherwise, you're going to basically ruin every event in your daughter's life, every birthday, every holiday, every major event such as graduation. You're going to ruin all of that because she's going to know the two of you hate each other so much you can't even be in the same room. So think about that when you're dealing with the other side. You don't have to see her. You don't have to deal with each other in writing by text messages or whatever you need to do. He is not prohibited under this order from communicating with you by a text message, but a threatening text message, a hostile or accusatory text message would violate the order I'm putting down. Okay. All right. Just have a seat outside, and one of you can go outside, the other can remain in the courtroom, and I'll issue that order.
Then we're doing court on Friday for child support. Will there be a way that we can be separated?
You can be separated at that point. Yes, while you're here in court. The bailiffs will assist you with that. Yeah,
Since I'm going to have no contact order with her, will I just contact her mother?
yes.
The judge delivers the final ruling. Protection is extended, but only for a limited 90-day cooling period. Custody remains intact, but exchanges are modified to reduce direct contact and future conflict. The warning is sharp and final. Protect the child, or the court will escalate consequences next time.